Hi, everyone. Thank you so much for being with us, and welcome to our third session of the DSA series. So we had our last pop queen, Rihanna, after we had Beyonce, Taylor, and now Rihanna. And we will have more of our queens in our next series that will be announced anytime soon. But in the meantime, a quick reminder of what we've been doing so far and what are we heading for today. So on webinar 1, which was 3 weeks ago, we had the Do-Re-Mi of the DSA, focusing on providing a comprehensive overview of the characteristics, the goals, and the framework of the DSA. We placed it into the context of prior European legal structures. So that was our first webinar. Then on our second webinar, we started to get our hands more dirty, focusing on the DSA provisions. We had recommender systems and terms of service, with a specific emphasis on compliance by TikTok. So you probably remember that we analyzed how the DSA influences TikTok's platform documentation and the contractual relationship between the platform and its European Union consumers. So that was webinar 2. And today we have again our legal experts, and we all intend to pivot towards the crucial subject of enforcement. So our legal experts, Catalina and Jacob, will explore 2 key aspects. First, how the DSA establishes the concept of trusted flaggers, and define. Oh, sorry, I have my Alex going crazy. Second. Sorry, yeah, it's a corgi going crazy. Sorry. So we have the trusted flaggers and how the DSA defines a role in content moderation as a measure against illegal content on platforms. And second, we're gonna have the DSA's data access displayed by Catalina. This provision for monitoring and evaluating platform compliance, as well as enabling vetted researchers to conduct research on systematic risks. So now we'll hand over to our legal experts to start and to embark with us on this short journey.
Thank you so very much. Thank you, Tom, and very nice to see you, everyone. Jacob, I believe you can start with the flagging discussion, the flagging of content under the DSA, and then I'm going to continue afterwards with the data access discussions.
Cool. Thanks a lot. And thanks, everyone, for making the time to listen to us babble about the DSA. I'll try and see if I can share my screen for the slides that I've prepared. You should be able to see it now. Is that working?
Not yet. Can you try again?
Yeah. Okay. Still nothing. Still nothing. This one then? Is that working?
Not yet.
Ugh. Oh, wait, never mind. I think I got it. Yeah, that's it, right?
Yeah. Now we have it.
Cool.
Great.
All right. Thanks. Sorry for that. I'm not used to using Zoom. So I'll talk a little bit about enforcement under the DSA. And I'll make it a little bit broader than the trusted flaggers that Tom and Catalina talked about. First of all, because trusted flaggers are, I think, are quite a small concept in the grander scheme of the DSA. It's only one article, and it's, let's say, probably not the biggest player in content moderation. It is very interesting from a legal perspective, but I don't think in sort of practical terms, it will have the biggest impact of anything that you can think of in the DSA. So I'll try to make it a little bit broader and look at how that sort of framework situates within the broader framework of a term I will try to use carefully because I'm surrounded by media scholars now, network governance. So in a legal crowd, you can use this term probably quite loosely, but you guys probably know better than I what it is. So I've looked up the definition, and I think it applies to content moderation and just platform governance in general quite well, being that it's not the platform operator only that is in charge of making the rules, setting the rules, governing the platform. It's a lot of stakeholders are involved, being that it's either the government that will try to steer content moderation in a certain way, or even be involved in, issuing takedown orders, involved in flagging, as we'll come to see, involved in setting guidelines. But it's also users. Users are hugely involved in content moderation, be it by also being able to flag content, being able to report content, being able to add context to content now on Twitter, which I think is very exciting. There's advertisers who will have their own say on how content moderation is going to happen, and that will also determine partly what content is more visible and what isn't. So it's a lot of actors that are engaged in governing the social media sphere. And that is both by design and has organically, I think, come to be in this way. And I think trusted flaggers are just one exponent of that, which is the involvement of outside parties, so external to the social media platform, to ensure that content moderation is more streamlined, perhaps add a little bit of legitimacy by adding civil society organizations, and in that way, sort of helping themselves as well. It's all part of the process of governing a social media platform. Now, trusted flaggers are based on the DSA Article 16, in which it stipulates that any social media platform must have a specific mechanism in place for users to report content. And that mechanism has to be easily accessible and user-friendly, and there's a bunch of requirements. I'll very carefully go to the next slide, which is I just print screened the article in there, so that you can refer to it as I'm sort of telling you about it. So there's sort of a few peculiarities about this. So most social media platforms will have something like this in place already, and that's partly because it helps the user, but it's also partly because it helps them moderate content better, being that if Facebook has 2 billion users and all of them are moderately active, then they'll have 2 billion content moderators being able to flag content that they do not want to see. Now, the Article 16 limits sort of that mechanism to illegal content. And we spoke about this in the previous sessions, that illegal content is any type of content that is illegal under national law, or that is in abidance by EU law or EU law. But this is just a legal definition. So it doesn't necessarily refer to terms of service or community guidelines, which are documents that you can now flag by. So this is really more of a legal referral button almost. And you can see that in the previous slide. The previous slide, yeah. In which you can actually see that Twitter has created 2 separate buttons. So there's the report post, and there is the report EU illegal content, which is a direct effect of the DSA mandating that very button. Like, you'll have to be able to report content under EU law. So there's a separate DSA button on Twitter. On Instagram, which is the sort of the choice menu that I print screen there underneath Twitter's, you can see that the very bottom option is report as unlawful. So that means that you can select all of these things that are also unlawful, by the way. Let's say the sale of illegal or regulated goods is just as unlawful as any sort of other type of illegal content. And you can get to their separate DSA menu, which then asks you to do exactly the same thing. So, okay, your content is unlawful. So what is it? Is it nudity? Is it hate speech or whatever? But it's a separate menu, which to me is interesting, because this seems to overcomplicate notice and action mechanisms, which are already pretty complicated. So the article stipulates that the notice and action mechanisms must be easy to access and user friendly. But if you ever try to flag content on Instagram, you'll spend more time than filing a police report. So it's how this will further play out in the future, I'm not sure. I'm also not sure whether this will lead to sort of any enforcement issues where digital service coordinators will knock on Instagram's or Meta's doorstep and say, well, your reporting system is whack. I don't think that's going to happen, but it is interesting to consider. But these are the notice and action mechanisms by which any user can flag a piece of content, and then the social media platform will have to consider whether that piece of content is illegal or not and attach a remedy to them, be it either removing the piece of content, perhaps demoting it, so shadow banning, or blocking it in a specific region, maybe demonetizing the account that posted it, or just that specific piece of content, or perhaps blocking the account overall. And for each of those remedies, the social media platform will need to create a statement of reasons for the user that's affected by the remedy. And this is pretty big. So I've added there the data of the transparency database of today, which now holds over 800 million statements of reasons, which each platform has to is mandated to send into the database. So there's 800 million content moderations decisions being taken since late September. And this is just on the very large online platforms, which also have been sort of taking to this in sort of with varying levels of gusto, I'd say. So Twitter has almost done nothing, and then Google Shopping has tried to essentially DDoS attack the database by issuing so many statements of reasons. So these statements of reasons must then hold specific information for the user by which it can, he can sort of, or they can identify what they did wrong, what specific piece of content is concerned, what rules the user violated, what the appeal mechanisms are, etc., how the piece of content was detected. And the interesting thing is that the requirement for social media platforms to issue statements of reasons applies to any restriction of the visibility of specific pieces of content. And this to me feels like there could be a tension at some point, because demoting content also means that shadow banning is now no longer shadow banning, it's just banning. Like if your content is now unfindable, according to DSA, you should be issued a notice explaining to you why that is the case, what rules it violates, because any restriction of visibility also means just demoting the content. Which raises another sort of almost philosophical question that Catalina discussed at some point. If promoting certain types of content, let's say just TikTok's general algorithm, it chooses content that it wants to push. That means de facto also reducing the visibility of other pieces of content, meaning that if I have to scroll through the entire homepage, I won't be able to see certain pieces of content just because other pieces of content are promoted. So any sort of content moderation action then is a restriction of visibility, which, I mean, that's not going to happen in practice, but it is sort of one of the, I think, lacunae in the DSA where you could ask, well, has it really been thought through? And the same goes for community notes, which is a content moderation remedy used by Twitter now that I'm actually pretty excited about. Does this entail a restriction of visibility? Meaning that if I attach a community note, which you can use abusively, to a piece of content, does that mean that as a platform, I'm reducing the visibility of the content because I'm drawing attention away from, let's say, Joe Biden's tweet in this case, by creating this huge sort of context post that might or might not be correct? That's community decided. Like there's no one at Twitter actually verifying these things. So to me, this is also a question for the future. If you engage more people in content moderation, you need to be able to explain all of those things. And you have to see whether the rules that we've created for, let's say, almost more traditional content moderation remedies in the DSA will also apply to the content moderation remedies of the future, which are likely going to involve more external stakeholders. Right. So trusted flaggers, which I was supposed to talk about before going into all of this. Trusted flaggers are essentially organizations that can do what any of us can do. They can use Article 16, notice and action mechanisms, to flag illegal content to the social media platform. And the social media platform will have to decide whether that content is in violation of the law or the terms of service agreement, and will then remove the piece of content. Trusted flaggers have a distinct advantage in that they do so via prioritized channels, meaning that if I flag a piece of content, it just ends up on this giant hill of flags, and perhaps it will be treated, perhaps not. If a trusted flagger does so, it's supposed to be treated within an adequate amount of time. And whatever that is, that's very unclear. Like the DSA talks about time periods very loosely and is never specific about how much time that is. But it should be quick enough. And then that's their advantage. Like they can do so via a prioritized portal or channel. Twitter has one in place already, I think. And with that, they can flag content like any of us. So you probably think, oh, so what's the big deal? Well, there's sort of two things. So the trusted flagger framework isn't new. It has been around since, I'd say, the early 2010s, with YouTube or Google and YouTube being one of the first ones to offer some sort of trusted flagger partnerships to organizations or individual stakeholders that want to be involved in moderating content. And if they have built up enough trust with the platform, or the platform trusts that they will do their job well, then they'll be able to access those prioritized channels, and their flags will be treated more expeditiously than other flags. So this article only formalizes what's already been going on. And the reason for that is what's been going on is very opaque. We don't know, we don't have an exhaustive list of all trusted flaggers. We don't know the exact arrangements that they have. We don't know their power. We don't know how those prioritized channels look like. So this is one way of trying to make it more transparent. And the way that goes is as follows in the DSA. The trusted flaggers are appointed by the digital service coordinator that we talked about in previous sessions. They are appointed on the basis of particular expertise, which is decided by the digital service coordinator. And they'll have certain reporting requirements, meaning that they need to report to the digital service coordinator on how they operate. The digital service coordinator has the power to take their trusted flagger status away if they are deemed to misuse it or no longer do so with a sufficient level of diligence. And the digital service coordinator will report to the commission how the trusted flagger framework is working in their member state. One caveat to this is that according to this article, the trusted flagger can only make flags on the basis of Article 16. So the normal notice and action flags, which are then again based on illegal content, being only only content that is in violation of EU law or member state law that is in compliance with EU law. So this drastically limits the power that trusted flaggers have, as opposed to the power that they have now, because now they can flag content on the basis of community guidelines, which is everybody's preference. Under this article, theoretically, they won't be able to. I think in practice that will not be the case, but still, theoretically, the DSA minimizes the position of trusted flaggers. And the second thing is, and this is a question that's like, I don't know, we've been discussing for a while. So who actually are these trusted flaggers? Because people talk about them, and the term is often used when it gets to, so what do we do about hate speech? What do we do about misinformation? Everybody says, well, we need more trusted flaggers, because it is a way to sort of streamline the content moderation process, because platforms will be able to get to illegal content more expeditiously, and civil society organizations, if they are involved, are able to perform that task more adequately. So from that perspective, this is an ideal situation. The problem is, if we look at sort of, at least in the Netherlands, and some of these organizations are international, so who have been performing such roles? Like, yes, it's NGOs. It's organizations such as In Hope, which I think targets CSAM content, or Hate Aid, which is about hate speech or discriminatory content. But it's also Europol. and it's also the national police in the Netherlands. Which already raises another question, which is a question of subsidiarity that I'll get to afterwards. But it's also the national, in the Netherlands at least, is the National Ministry of Interior Affairs. And it's the consumer authority, but also I have to be careful now, the food and consumer authority. Meaning that those are state actors that are now have prioritized channels or access to a social media platform to suggest what content the social media platform has to remove. And legally, I think this is interesting, because usually when a state wants to remove content or wants to in some way sort of limit your freedom of expression or censor whatever you're trying to put out there, like they'll need good reasons to, and they need to be able to motivate why they're doing that, and do so on the basis of the law. In these cases, they actually don't need to, because it's a very informal channel. You just flag a piece of content on a social media platform, and then the platform decides whether it stays online or not. So if the Ministry of Interior Affairs flags a piece of content, the question then is, does the platform have a final say in whether the piece of content stays online? Or are they so obliged by the pressure that's exerted from an email from the Dutch Ministry of Interior Affairs that they will automatically remove that piece of content? And how large is their discretion in that regard? And on this question, I've been trying to speak to sort of different ministries in the Netherlands on how that works. And they have different interpretations. Like the soon-to-be digital service coordinator says, well, now we expect platforms to make their own evaluation. And then the Ministry of Justice says, well, if we flag a piece of content to the platform, they better soon take it down. Or if they don't, we actually expect them to have very good reason not to. So there's different types of pressure, which also change the level of tension that you have with the freedom of expression there. So the subsidiarity question that I was going to get to was, if the police wants to remove a piece of content, they have the power to do so under Dutch law. There is opportunities outside of the DSA to remove content with a court order. I've put the Twitter sort of law enforcement mechanism in there. But also under the DSA, you can, as an administrative authority, go to the digital service coordinator, say, okay, I want that piece of content removed, and you can get an order, and the platform will have to remove it. The question then is, if platforms, if national authorities such as the police have such power, why would they need the more vague, more discretionary power to flag content on a prioritized channel as well, in which there are way fewer safeguards for fundamental rights concerns? And I think the answer to that question is scale and speed. So it's a lot quicker to just flag a piece of content directly to the platform, and then the platform will remove it, and you don't need to bother with sort of legal requirements that you would usually have for such a request. But it is still a question of how do we feel about these powers being given to state entities when they also have more formal, more, I'd say, safer powers, at least to the citizens, available to them. Now, this is essentially sort of the legal questions that I deal with, meaning that if state entities or governmental bodies are involved in content moderation, how much pressure does that put on social media platforms? What are those state actors? Who appoints them? How are they constituted? Who checks them? Why do they engage with social media platforms in this way and not in any other way? And what's the legal basis for doing so? And I think these are fun questions to engage with you guys on as well. I think this has sort of been, for me, talking about content moderation remedies. And if you have any questions, please shoot.
Shall we maybe indeed engage in some questions right now? Do you have any questions on trusted flaggers or the flagging system so that Jakob can already take those? As Tom mentions, feel free to unmute yourselves.
Maybe I'll kick our discussion a little bit with a question about thinking. It's also spinning back to some conversations we had about trusted flaggers. Maybe our participants will be curious to learn more about the identity of the trusted flaggers, in the sense of like how do you make sure, what is the process of making sure the identity of trusted flagger, in the sense of like which type of validation they need to go through, and what secures that, you know, trusted flaggers will not take advantage of their power, or will promote certain agenda or use their influence in certain ways that usually we see on platforms, how people find their way into misuse and manipulation. So just curious about that, because at some point, I guess people will be caught up with questions about when trusted flaggers will be already a well-facilitated thing, those questions will pop very quickly. So if you can give us the context on that, and then we have a question from Daria afterwards.
Yeah. So I suppose you need to answer this question in two layers, meaning that who are trusted flaggers right now, and then who will be trusted flaggers under the DSA. So right now, platforms can decide for themselves whoever they want to appoint as trusted flagger. And that's it, essentially. So we know of some organizations, and also some organizations actually sort of broadcast their role as trusted flagger as to engage with more people that they can help. For example, I think In Hope will be very sort of public about their role as trusted flagger, because it attracts more people that come to them with problems, and then they can engage with those problems with social media platforms. I think sort of governmental institutions have been more careful about this, or at least not as open, but it's also not sort of the biggest sort of thing in the world. Now, under the DSA, platforms will no longer get to appoint trusted flaggers themselves, but the National Service Coordinator will, National Digital Service Coordinator will be able to do so. And this has the interesting implication that those trusted flaggers can be appointed by, let's say, service coordinators that have different political views than you would in any other European country. So let's say that there is a concern of a Dutch sort of climate skeptic organization becoming trusted flagger. Will they be able to flag content across the European Union? How likely is it that they will be able to do so? And does that mean that we'll all be sort of devoid of any accurate climate change information because that will all be flagged? So I don't think it's going to come to that point. The digital service coordinators at the moment are still being set up. They will have to create sort of criteria and requirements on what organizations can apply for that status. As far as I've gathered, they're still, at least in the Netherlands, they're still working on that. And their main requirement is sort of legal expertise on the field that they're trying to flag content in. So that means that not just everyone can apply. And then there's also questions on, okay, so how does the application process go? Can you appeal the process? Can I appeal the process of someone else being appointed as trusted flagger? Because it's sort of a public role now. They were all still very unclear about that, but I think there's also a huge sort of safeguard when it comes to the social media platforms themselves. So at the moment, they select who they want to engage with in their content moderation process. And in theory, and probably in practice, they still have the final say on who takes down, on what content is taken down, because a flag is still only just a suggestion of, is content infringing? So social media platforms also, in that sense, have a huge responsibility in weighing the level of expertise of a trusted flagger or an appointed trusted flagger, and then deciding whether they will abide or not. I think that's sort of how I would see that. But I've seen that there's already a question in the chat, and then Claudio has his hand raised as well, and then Daria had her hand raised as well.
Right. So maybe Daria, you want to go ahead with your question, and then we'll have the question from the chat, and then Claudio.
Cool.
Yes. Thank you. Sorry, I cannot turn my camera on. I'm in the car. You actually answered already almost everything I wanted to ask. Just one little thing. Are they going to be compensated somehow, and from where? Like, would there be, like, I don't know, funding from nation state, member states, or from the EU, or?
Yeah, no. So it's not it's not an institution that the DSA is trying to raise. It's just, let's say that I am an enforcement body at a national government, or I have an NGO that wants to help certain minorities. I can apply for trusted flagger status, and that will help me do my job better. But it's not sort of that the DSA is enabling extra funding for a better content moderation process in that regard.
If I may just add something that we were just discussing yesterday as well. So I think that one of the requirements of trusted flaggers is that they are independent from the organizations that they are flagging content to. So that completely removes any kind of possibility of saying, okay, then Facebook is going to have just kind of, it's going to be a new form of a content moderation organization, but then a trusted flagging organization. And I think that here, because we have such a diverse landscape of interests and also such a diverse landscape of stakeholders, so we can have public institutions, they will be publicly funded, but then we can also have perhaps NGOs. And I think it's important also how we look at flagging in general, because it depends on the platform. I think that right now we cannot even compare a platform like Twitter, which is absolutely abysmal in its content moderation and at the moment, and this is something that is widely reported. We cannot compare that, for instance, with the efforts that we know, although perhaps incomplete and very much imperfect, Meta has been doing in its own content moderation teams. So I think it also depends very much on how we see the role of these trusted flaggers. Are they really, some sort of a vehicle that outsources the responsibility of a platform, which I would say, for instance, with the community notes, that is the case of Twitter right now? Or are we speaking about just trying to correct the path of an organization that is trying to do things well with automation or without automation, but it will not be able to do everything perfectly, like 100% content moderation accurately. And so that's just a note I wanted to make.
Yeah.
Great. Maybe do we have Joanne? Maybe you want to ask your question, or we can just read it from the chat, or whatever feels comfortable. Do you want to join us?
Yes.
Great.
I am interested in contribution. I'm from the US, and people who do various political acts find themselves doxxed and all of that. And I'm just wondering about the protection of the flaggers in the case of some dicey political issues.
Yeah.
That their identities would be shielded.
Yeah, the identities are shielded just as they would in sort of any normal flag. Let's say that I flag a piece of content, like the person whose content is flagged will not know that I flagged it. And the same goes for the trusted flagger organization that flags that piece of content. So I wouldn't say that you'd have to be worried as an NGO that certainly people are going to protest your doorstep for censoring the internet. That said, I have or am arguing in a working paper that I think for sort of government bodies acting as trusted flagger, it would be helpful if their identity of the body was released in the statement of reasons. Because if you have this sort of indirect censorship going on, I think it would legitimize the government interference in the content moderation process if at least they disclose that they're doing it. and who the sort of entity is that's doing it, so that perhaps there's also multiple ways of appeal there. But other than that, I think you're safe.
Thank you.
My turn.
Claudio, would you like to ask your? Yeah, yes, thank you.
Thank you. Yes, I've also brought them because maybe it's easier. But I saw the paper you link, Tom, and I'm quite aware because I'm a researcher in recommendation and shadow banning. But my two problems are: shadow ban is a term that every platform implements differently. There is not a very standardized term. For example, in YouTube, maybe that some videos do not appear in the homepage, or do not appear in the research results, or do not appear suggested in the recommended column. In TikTok, similar or even more. I mean, in every portion of the app, there is a different algorithm that can play, and a content may be hidden from there. But there is not a shared agreement on what shadow banning is, or what does it mean diminishing the reach. And I wonder if there is some work in progress to standardize this term, because if it became a solution, it became a power, it needs also to be quite codified. And the second question is slightly related. If I am subject to shadow ban because I'm getting sanctioned by a platform, how do I know it? So far, we rely only on anecdotal assessment from content creators that complain the lack of likes or views, but that cannot be used as a strong evidence. So I just want to put those elements into the question. Thank you.
Yeah, I think those are sort of great questions. I think shadow banning itself, I think as a term, is not even mentioned in the DSA. I was trying to look through the preamble just now, but I couldn't very quickly find it. I think what you're pointing at is what I call sort of the gap in DSA phrasing, because the way that the DSA right now in Article 17 is set up is that if you're suffering from a content moderation remedy, of which shadow banning is one, and shadow banning can happen in very different forms. But if you're talking about overall visibility sort of decrease, that's a content moderation remedy. So whether that happens in different ways in a variety of platforms doesn't actually matter in terms of DSA phrasing. The problem is, and that gets to the second point of your question, how do you notice it? And theoretically, under the DSA, you would get a statement of reasons as to why you're being shadow banned and how that is happening and who's detected a piece of content that is violating either the law or terms of service agreements so that you're being shadow banned. The problem is, and I wonder whether this will happen in practice, because it's very hard to check if you're being shadow banned. So it's also very hard to hold a platform accountable for not sending you a statement of reasons if you're being shadow banned. So I think, yeah, you've identified, I think, a good pain point in the DSA and certainly in Article 17. That's my take on it, but I'm not necessarily the world's biggest expert on shadow banning, so that's just from my cursory reading of the DSA.
I'll just add a quick note on shadow banning and platforms' response to that. As part of my work with Jewish creators and their struggles of visibility on the platform, they usually communicate their struggles to the platform, and you never know when you're shadow banned. It's kind of like a feeling, or at least like a feeling that is more it is more anchored in experience. That as a content creator, you have a lot of experience about your performance in the sense of like engagement. And when you feel shadow banned, it's a feeling that is very much supported by your experience. But when those creators interact with TikTok, for example, on shadow banning, TikTok deny TikTok denies in any way the ability to be shadow banned. They don't really acknowledge that as something that is taking place. Well, those creators are saying, wait, if I am shadow banned, I can see it in my performance, and I can see that I am that my visibility is stuck, or is not really kind of like reaching to the peaks that I know, and you don't have any reassurance of that. So you kind of like left in the dark with your feeling when it comes to shadow banning, which is very hard. And the paper that I shared with you by Carolina Ara speaks more about this feeling of shadow banning and how creators are actually making sense of it. So it's really interesting context for content creation. Yeah. And yeah, now we have more stuff, but that's like a discussion about the report.
I think Daria has her hand raised.
Oh yeah, sorry, Daria.
It might be relevant to the sort of discussion that's going on in the chat that I also haven't read.
Yeah, Daria, if you want to also kind of like take the opportunity on saying something about your beautiful report, that would be great.
Yes, actually, I wanted to say something. We did this report of the 1 day of content moderation with the data that platforms actually do submit, and they actually submit a lot of decisions on demotion. And I even called it that maybe this is the end of shadow banning in the EU, because TikTok does submit statements, Meta does, a lot of them do, even X, although it doesn't submit a lot of statements overall. But YouTube didn't. That was weird, but maybe it was just a day like that. We should look into more information. So it is interesting. And I think at least theoretically, they should send notifications now, but that is still to be checked. Yeah. Okay, thank you. Some promotion.
Please keep joining us from your car. We're loving the look. Great. Do we have any more questions? I'm trying to see if the chat refers to something specifically. Yeah. Okay. So yeah.
Before we move on, I was just wondering, Jakob, could you say something also about, I guess, the tension between what's going on here with content moderation and then issues of like I guess the GDPR and the need for people's privacy to be maintained in terms of, you know, how we might go about knowing more details about these moderation in order to, yeah, how do these things fit together or complicate what we might be interested in?
Well, GDPR questions. I'll try to answer that as best I can. I think it's one of the sort of the big paradoxes of the internet, being that if I were in the real world and somebody told me not to say something, I would want to know who that person is and where they got off on telling me that I can't say something. The problem is on the internet, you don't have that same logic doesn't apply. Because there's very good reasons for people to be anonymous on the internet. If I'm of a certain minority, or if I have a different identity on the internet, that's perfectly fine, and you should be able to. So how does that make content moderation more difficult? Well, it sort of detracts from legitimacy, because this also raises the opportunity for abusive use of notice and action mechanisms, being that if I can just create an anonymous account and then just report the shit out of, you know, my political opponent, find whatever reason to get his content offline, and nobody will know it was me. And there's nothing he can do about it, because nobody can know it was me, because we have the GDPR. So, but then again, let's say that I am of a certain sort of a minority that needs protection on the internet, then it would be very helpful for me to anonymously report content. So there is a paradox there. And that's all I really can say about it. That there is a legitimacy in knowing who people are. And I think that, you know, even politicians in the recent Dutch elections have argued that, you know, everybody should be able to disclose their identity, should be required to disclose their identity online, as to prevent sort of hate speech or political threats or whatever. The problem is that that's not really how the internet works, and there's very good reasons for people to be anonymous. And there's very good reasons why the GDPR allows people to be anonymous. That said, also in content moderation, there are certain exceptions to platforms sort of being able to withhold information about people that post illegal content online from national authorities, in the case of CSAM, I think. So in those cases, the platform must actually disclose information to a national authority seeking to, I don't know, prosecute that specific user. That's all I really can say about it.
Great, thank you so much. I think that we are ready to embark on our data access session. So
fantastic. Thank you so much, and thank you, Jakob, for taking us through the wonderful world of trusted flaggers, and also the very complex questions that arise out of that. So after we learned more about flagging and the DSA, now we're going to go immediately into data access. And I have a disclaimer. This is going to be a discussion and a presentation that will be very, very legal and also very verbose. But I thought to take this strategy very specifically because I think it's important to also show you what exactly enforcement will mean in practice. And in the legal field, I think, at least in my perspective, enforcement is something that is it's something that is very administrative. It's very bureaucratic. It's about creating processes that individuals are going to have access to, and the DSA gives us at least a starting point to understand these processes. The core of our discussion is going to be Article 40 of the DSA. That is the data access and scrutiny article. In the first 3 paragraphs, it speaks very much about the investigation powers of the National Service Coordinator, the Digital Service Coordinator. We see these kind of investigation powers as more of the public enforcement that the authorities tasked with the implementation and the actual running of the DSA will have in practice. The powers, the legitimate investigation powers, the legitimate enforcement powers. So that is a very large chunk of the DSA. And for some reason, Article 40 kind of bundles these powers of institutions. So institutions, public institutions that are going to be basically the police of the DSA, so to say. But then also bundling that with the research access for actual researchers, so not for individuals working for these organizations. So I think I'm just going to try to take you one step at a time through Article 14. Again, I'm just going to emphasize some of the important conditions here. And before we begin to dive into it, it's also very important to note that at least in the type of instruments that I'm familiar with when it comes to platform governance, particularly from a consumer protection perspective, this simply has not existed before. So I think that Article 40 is really an element of novelty. There has always been a dimension of, okay, let's give some rights to researchers. You will see a very interesting cross-fertilization with some copyright, with a copyright instrument that we will actually even get a definition from, that of research organizations. So there are some acknowledgements of researchers in European law and the need to have research and data for research more specifically. But the kind of powers that we see in the DSA are, I really think, quite novel and also just completely, they haven't been included in such an instrument before. So what is very important to note is already we have the Digital Service Coordinator playing a central role. And what happens is that the Digital Service Coordinator of establishment, that's also very important to remember. It's not just any kind of Digital Service Coordinator in the European, in the different member states. It's the Digital Service Coordinator of establishment that is going to be granting the vetted researcher status to different researchers who meet the requirements of Article 40, paragraph 8. And that is going to be for the very specific purpose of doing research on the detection, identification, and understanding of systemic risks in the European Union. So we will come back also to this question of systemic risks. And we will also try to understand a little bit better what it means to have conditions for vetted researchers. But I also just once more want to emphasize the fact that here in this particular article, we have digital service coordinators of establishment. So remember that we have 27 member states, unfortunately, right now, 27 member states in the European Union. Every single member state is going to have a digital service coordinator, but, and we're speaking about European researchers from all of these member states, but in order to become a vetted researcher and for you to have access to data, for instance, from TikTok, then you need to become a vetted researcher as per an application made to the digital services coordinator of establishment, namely where the country where TikTok is established in the European Union. And that already creates some very interesting implications, because you will see, we even made a list when it comes to the very large online platforms, so we can see where exactly they are established, that we will see some very interesting patterns there. So digital service coordinator of establishment, we can see in the definitions, is the digital services coordinator of the country, the member state, where the main establishment of a platform is going to be located. So, and then we have digital services coordinator of destination. So, for instance, you have a country where other users can benefit from the service. So, for instance, we might be, or most of us might be, TikTok users, and then for instance, depending on whether we are in European Union countries, then there would be a digital service coordinator of destination in that case, if we notice any kind of illegal content, so to say. So these are, I promised that I would show you some of these discussions of establishment. So there was also under the DSA a requirement for different platforms in the European Union who are active in the European Union to report their number of followers, their number of users. I'm very used to social media platforms nowadays. Their number of users, and then we have a standard in the Digital Services Act that platforms that are going to have more than 45 million monthly active users will be designated as very large online platforms, and additional rules will be applicable to them. And particularly the systemic risks rules are relevant for these platforms. And we also have very large search engines. And I don't know if Daria is still available, but last time I checked, to interact with us, but last time I checked, I believe that the DSA transparency database that was supposed to already report on all very large online platforms. So all very large online platforms were supposed to actually have their statements of reasons uploaded there. And I believe it was only 16 or 15 of the VLOPs that were submitting content. So even though there is an obligation for all of them to do so, not all of them actually do so. So I don't know, Daria, if you have any, if you have seen anything recently in that database.
No, we have only looked at social media platforms specifically, and there were 8 of them, and we didn't check the others. So, but I have a question. Something has to change in February this year, like for other digital platforms, but they're not going to have these extensive obligations. But what are they going to have? I don't know if it's...
Yeah, so in February, basically the DSA will enter into force. So right now the DSA has partially entered into force, and it only applies to some actors, such as these very large online platforms that already have an obligation to report on their content moderation practices. As of February, I think it's like, what is it, Jakob? It's like 16, 17 February. The University of Amsterdam is going to hold a conference specifically to mark those particular dates. The DSA Observatory at EVIR at the University of Amsterdam. And basically, as of that moment, all online platforms in the European Union will have an obligation to submit statements of reasons in the DSA transparency database. So that's going to be absolute insanity. Of course, we can speak about, these are the largest, perhaps this is where, like the crux of all of the content moderation decisions will be. But I am very curious because at national level, we don't even have lists, of what's a list of online platforms in a specific member state. So at least from that perspective, it's going to be interesting. So I'm just going to focus on the very large online platforms, which basically have not only social media platforms as in Daria's fantastic report with Christian, but also different platforms such as Google Shopping, Google Maps, Google Play. We have also very, very established marketplaces, Amazon, Alibaba, AliExpress, and even Wikipedia. So that's very exciting. And now let me show you. So after some research done today, which also gave me quite a lot of pause because I have been going through terms of service of Alibaba, AliExpress, available to me as a European user loading the website from a European IP address. And the most I could find is that there is a legal entity in Singapore that contracts with European Union citizens and consumers, and that is not okay because also under the DSA you have an obligation as a VLOP to register a legal representative in the European Union. So that is a little bit bizarre. But let me see if you notice the massive trend in this list, because there is one country that basically is just going to be the lord of the VLOPs, and basically there will be one very important national digital service coordinator, and yes, you have seen it, that is the Irish National Service Coordinator. The problem here is that so I'm not an expert in the GDPR, but a lot of my colleagues who are experts in the data protection law, they look at the GDPR as an instrument that also had this entire establishment principle. So you would have also, as it happened because of the fact that all of these platforms are based in Ireland, a very big enforcement burden on the Irish data protection authorities. And the problem is that has actually stagnated the enforcement of the GDPR. So everyone is now saying, or let me say it is a very general perception to be worried that if we're going to just leave enforcement to one specific member state, that is going to be a problem. I don't know if that is still public information. Maybe Taylor, you can Google it really quickly, but I think that there have been some news items or at least some rumors around that the digital service coordinator in Ireland is hiring up to 140 people to staff an office that is going to have to deal with all of these platforms you see here. And so we have, apart from the marketplaces, we also have this outlier, Booking.com, that's located in the Netherlands. But then for Facebook, for Instagram, for LinkedIn, for Pinterest, TikTok as well, YouTube, everything is based in Ireland. And I think Dan is also mentioning, some of the very unpleasant effects of everyone moving to Ireland, especially in Dublin, because there are also some very unfortunate negative effects locally. For instance, the very, very increased pricing of housing. Now, we also discussed that we are going to look at paragraph 8. Paragraph 8 puts forth the conditions for vetted researchers. So the digital service coordinator of establishment, remember, so in this case, the Irish National Digital Service Coordinator will have to look at different applications and see, okay, can I give you as an institution a vetted researcher confirmation? So can I grant such an application? And we have some conditions that I would like to go through one by one. And then we also have a definition that I told you about is outsourced to another document, which is the copyright directive. So first, the first condition is there needs to be an affiliation to a research organization that is defined in this particular copyright directive. I will immediately move to it so you can see what this means. So the copyright directive that also dealt with some text mining and database exemptions from liability, from copyright liability for researchers, defines research organizations as a university or libraries, research institutes, any other entities, the primary goal of which is to conduct scientific research or to carry out educational activities, either on a non-for-profit basis or pursuant to a public interest mission recognized by a member state. So we have, this is the definition of research organizations. And here you have also this dimension of neutrality and independence of these research organizations. And it took me forever to really find an answer to this question, because here you can see that the definition itself doesn't say that these organizations need to be per se in a member state, but the recital 12 from this directive actually refers to research organizations from across the European Union. What is also perhaps necessary to mention is that every single member state is going to have education law that is going to say, okay, we have these universities that have been accredited. We recognize these universities as research universities or as research organizations. We recognize these particular institutions or institutes as research organizations. So there will be a plethora of additional national law that will be relevant in determining who exactly is going to have the standing of a research organization under this definition. So this is the first requirement. Then the second requirement is this independence from commercial interests. So the moment when there is any kind of commercialization at stake that is not fulfilled anymore, so then that means that there needs to be this idea of developing research for the sake of public interest and not necessarily for the sake of developing commercial products. We have a transparency requirement if there is any funding. So for instance, if there's a grant that supports the research time of researchers, then we have something like the disclosure for the funding of research. And very important, and I say this also from the perspective of having gone through quite a lot of headaches with our European Research Council starting grant, because the thing is that there are certain data security and confidentiality and pseudonymity requirements. For instance, also compliance with the data protection legislation, which are now, I think, increasingly in different European Union, and particularly in the Netherlands, where I have seen some practices, there is this increased also proceduralization of all of these requirements of data security and confidentiality, but they are not really easy in practice, because imagine that you want to ask for social media data, then you need to showcase not just data security in terms of practices of hosting that data on your servers, on the servers of the university, but then sometimes even in order to comply with the GDPR for that reason, then there can be some very deep implications, for instance, for the pseudonymization of data to the extent that you do not use data that is provided by a platform from an API, which used to be the case, for instance, of Twitter, that actually pseudonymized data for you, and then you could just use the research API to retrieve that data. And provided that you don't necessarily publish it, then certain standards were as such already met on the side of the platform and not necessarily had to be done by the researchers. And then here, I think it's also a demonstration. This is a requirement about the demonstration that the kind of data is proportionate, it's necessary for the purposes of the research, and also some expected results. Again, I think as a researcher, I find that quite difficult to ascertain, but okay, interesting requirement. And then the kind of an overview of the research activities and a commitment that these activities are going to be carried out for the purposes of paragraph 4. So remember, paragraph 4 was this one. So the detection, identification, and understanding of systemic risks in the European Union. And then very nice requirement of publicly available, free of charge, within a reasonable period after the completion of the research, requirement that regards research results. So that is basically also the European Union's commitment to open access research. So these are the requirements that are laid down in Article 8. You can see they're quite, in a way, they're quite reasonable, but some of them, if you start digging and you start thinking, how should we interpret this? For instance, even the one on what exactly a research organization is, they become a little bit difficult. And that's where we are going to need quite a lot of guidance from national service coordinators in terms of their assessment of these criteria. So the thing is that normally we saw in Article 4 that we have the digital service coordinator of establishment that needs to grant this vetted researcher assessment, or needs to grant this specific status. But the thing is that researchers can also submit applications in their own member state. So they can go to the National Digital Service Coordinator of the member state where the organization is located. And then that National Service Coordinator is going to send the application with supporting documents to the Digital Services Coordinator of Establishment. So then that means that the Digital Services Coordinator of Establishment will take all of this into account, will look at this application, and then simply decide by itself whether to grant that application of a vetted researcher or not. So that is also something to keep in mind. In addition, yeah.
Do we know like the time duration of this process? Do we have any idea of like?
No, but here we can see, for instance, here undue delay, without undue delay. This is a very typical legal time frame, which will very much depend on the capacity of the Irish Digital Service Coordinator, for those of us interested in social media platforms, and also the amount of researchers who will apply for this type of vetted researcher status. So again, it's a little bit of a blur, and we will also have to see, you know, what exactly a full application is going to look like. You know, what exactly does it mean that you have sufficient information? Where is it that you have sufficient information for the planned research activities? You know, that you can show proportionality, et cetera, et cetera. So that's something very important to keep in mind and to kind of keep track of, because this is pretty much history in the making. Another quite important aspect, because this article has been very widely criticized since it, in principle, only included these research organizations that have been referenced as universities, their libraries, or institutes in different member states. The criticism has been, but okay, so what about NGOs? So for instance, what about civil society? Are we completely excluding civil society that does research? And Jakob had some very nice examples of civil society organizations that actually can establish themselves quite easily as experts in very specific policy domains. And what do we do with those? Here we see that there is in paragraph 12, a very interesting provision that there can be, so access can be granted without undue delay to publicly accessible data on these platforms, on these very large online platforms. Also for researchers, including those affiliated to non-for-profit bodies, organizations, and associations who comply with the conditions set out in paragraph 8. So we have some access to data for NGOs, for instance, but then only publicly accessible data, and then that data is supposed to be, once more, used for the determination of systemic risks. And that is, I think Daria is already emphasizing the research access for that Meta has been granting for private data. I had an example that I wanted to very briefly discuss, and then perhaps Daria, I can just ping back to you so you can talk a little bit more about that, because that's quite interesting. So there has been this very big undertaking that Meta has completed, I believe, this summer. And that entails that Meta has opened itself up for, I think, I don't even remember how many universities participated in this, but a number of American universities participated in some sort of private data sharing, as Daria is mentioning in the chat, with this new initiative. But this was a very specific project with a very clear goal of looking at the US 2020 election cycle and trying to understand whether recommendations have different effects on political attitudes and behaviors. And the results of this research, which has been a collaboration between Meta researchers and also these academic researchers from different universities, have been published in very established scientific journals, also peer-reviewed, very important to mention, because we're talking about kind of like the gold standard of science. And these have been also very, very kind of large-scale, quantitative, experimental studies that could never have been undertaken outside of such a collaboration. And I think that for me, at least right now, this is an example of how the idea of studying systemic risks looks like, because I think that we all in this virtual room have interest in studying social media platforms, and I think there can be so many super interesting methodologies that we can use to garner intellectually stimulating results. But we need to also ask ourselves, okay, we have the procedures for data access and for the vetted researchers. The bureaucracy associated with that is one thing. Maybe the power dynamics associated with that is a different thing. But at the end of the day, we also need to remember that it's not just research for anything, it's research for systemic risks. And again, that brings back the question, what exactly is a systemic risk? And the reason why I wanted to emphasize this example is because I think for me, at least, this is a very good example of research that is supposed to really look at a risk that basically is a democratic problem with elections. And this in itself, I think, is even recognized by the DSA as one potential systemic risk, basically just interfering with elections and affecting the democracy in a particular state for that matter. So I think here you see like UT Austin, NYU, these are two examples of universities that were involved in this study, or the set of studies. I think in total they wanted, I think in total, let me see, was it here already? In this article by Nick Clegg, the global affairs guy from Facebook, from Meta, I should say, he mentioned that, I think in July, he mentioned that they were expecting to have in total 16 papers coming out of that collaboration. And it was a very large scale collaboration, also very, very kind of clustered in research questions that were linked together throughout the entire project. So that was quite an interesting undertaking. Which brings us to the challenges which I see for our academic community. When we speak about systemic risks, I think sometimes we're actually speaking about using different frameworks that are multidisciplinary, or that are inherently multidisciplinary, and that very often don't yet exist. So this is also why I find it so important to have more interactions between different disciplines, between media studies, law, computer science. And the thing is that I think we are faced with some very deep questions about what can our own discipline bring to the table for the discovery of these systemic risks. Because systematization in the meaning of the DSA, we can see that in recital 79 of the preamble of the DSA. We have an example here, in determining the significance of potential negative effects and impacts, providers should consider the severity of the potential impact and the probability. For example, they could assess whether the potential negative impact can affect a large number of persons. So we have an absolute focus on scale. We have an absolute focus on the architectures, the very fundaments of the platforms that we all have been investigating, and not just, a tiny little brick that you can bring to knowledge and to say, okay, in this particular situation, with this tiny little sample, with this tiny little example, we see these particular results. And because in some fields, these approaches, which are very important for exploratory phases, so you need to start somewhere with research, right? This is a very big topic that is also very much in vogue right now in European policy, the well-being of children, and also what is called addictive design with social media platforms. And we see just so much diverging evidence. And Taylor also participated in a fantastic panel this week. And perhaps you can elaborate a little bit more on that, Taylor. But we see that, for instance, in this situation, science is taking us in many different directions at the same time. And then the question is, how would it be even possible to start looking and measuring systemic risks if the science that is the starting point of such an investigation is completely all over the place. And we haven't, as the academic community, even agreed on some particular basics of what exactly we have found and what exactly we still need to find in this field. So this is, I think, one of the last things I want to say when it comes to potential trends for data access and also for the research of systemic risks, that we have a need to develop more complexity research frameworks. So large-scale teams, as we have seen also in the case of Meta, with bringing together different methodologies, like I said, trying to ask disciplines, what can you bring to the table and how can you contribute to unveiling something more out of the systemic risk, and looking for different insights, perhaps with different methodologies into the same data. And then also trying to have a kind of a starting point of convergence. So not necessarily just, looking at science and saying, well, we see a risk, we don't see a risk. Where exactly is our starting point if we do not agree and we do not have very clear insights, for instance, from systematic literature reviews that can show us a very specific empirical effect? And apart from the different empirical effects, for instance, we saw the examples of behavior and elections. There's also a very important tendency to consider platform architecture. So recommender systems would be one example of such platform architectures, recommender systems, content moderation architectures that are relevant, but also organizational management, because organizational management is about the processes that platform architectures are used in. And that's also very important to consider. And I think for content moderation, that is something that entails this automation dimension, but also the manual content moderation dimension. And something which I am very much interested in, but I think it is just such a complex topic, the methodological harmonization. We know in different disciplines, methods can pose, they can break friendships, they can make enemies. And I think that this happens not just in law, but literally in every single discipline. I think we shouldn't have a competition of methods, but I think we do need to have some degree of methodological harmonization. And in my view, I see a lot of divergences between, for instance, the computational methods that are used in computer science literature and the computational methods that are used in computational social science literature. Very often you see that research in computer science is much more advanced, for instance, when it comes to explainable AI, when it comes to trying to understand the defects and to understand the pitfalls of certain, for instance, large language models, whereas computational social research in some instances simply takes for granted, for instance, like a model that does language, that does, for instance, sentiment analysis without necessarily looking into its potential pitfalls. And then, the question is, what's the use of having these results if you cannot really ascertain the accuracy of a model? And going back, and I literally just added this during our conversation at the beginning. So if we speak very, very quickly about some TikTok examples, we have a research API that also TikTok has launched. I don't know how many of you are on there or are also even familiar with that. So for our project, we have access at with the TikTok research API, so we can discuss about that as well. I see Daria also mentions something about X in the chat. But the one thing that I wanted to comment, for instance, about shadow banning as well is the fact that the example of shadow banning is a very good example why perceptions and anything that is subjective can maybe be a nice step in the direction of understanding a phenomenon, but as such cannot replace the necessary empirical evidence that is needed. And I think that we were discussing this a little bit earlier in order to really see, okay, are you really losing out on your views, or is there more competition on the platform, or are your audiences simply reacting differently to your your content. So I think that not just the computational, but also the behavioral research that can be necessary around shadow banning before even considering it a potential systemic risk is just so broad because of the fact that methodologically, I think we're creating a lot of results, but we're not really bringing that together. But please do disagree with me if that is the case, or if you believe that that is not the case. Again, I will bring you back to what Paddy Laersen, so Jacob also mentioned in the chat, Paddy Laersen is a researcher from Amsterdam, and he made a summary of the different requirements that different researchers and also other organizations, including trade organizations, have requested from the European Commission and the expected delegated act. So the European Commission is going to bring in even more rules about how exactly are we going to appoint vetted researchers and what the procedures are going to be. And you can really go ahead and read this contribution because it gives you an overview of what people actually need. So I think that this was already a little bit over time, so maybe we can go to your questions. But Daria, you have shared so many things. Please share with us, what are your thoughts about data access?
I'm sorry, I feel like I'm bombing this. I'm
that's
just saying
great.
because it's useful. I think that this meta thing is really new. It's like the end of November they launched it, and there was something about private data mentioned. I don't remember exactly where, but I think they're building the system where you can work with data on their grounds, so that, you know, like not share with anyone, but work there. Let's see how it's gonna be. And yeah, X updated the developer terms. It was not last night, it was a few days ago. I just copied the post. And yeah, there's a little bit, maybe some useful information on other API access, although some of it is already probably not relevant. Yeah, that's all. I wanted to ask about, so as far as I understand, what universities are going to be designated as vetted research organizations. So we will not have to apply, because we were wondering, like, should we apply as Zemke? Should we apply as a lab? Would it be a university that needs to go through some procedure, or would it be automatic? That would be really helpful if you have an answer.
So I think we should actually, thank you so very much for your insights. Always fascinating to listen to you speak about your fantastic research, and also opinions in this space. So I think, according to my reading of the DSA, and we will need to also wait for the delegated acts to come, the thing is that vetted researchers are going to be, so the vetted researcher status is going to be something that has perhaps two dimensions. One, a institutional dimension, so you need to be affiliated with a research organization, and you need to make sure that you're independent, and then you need to disclose your funding research, your research funding and stuff like that. But at the same time, it's also a project. It also has a project dimension. So you need to show, okay, I'm going to study a systemic risk, because I think, and like, let's put ourselves also into the shoes of a platform. You have all of these requirements under the GDPR. They are basically like the sword of Damocles over your head, because the GDPR is this kind of, carrot and a stick that the European Union has created already for some years now. You do not want to give too much data to access, right? And you also do not want to give data to access to data to researchers perhaps who don't necessarily need that data. So this data minimization principle, it's going to be very interesting to see how the GDPR will interact with this article from the DSA, just to make sure that also the DSA, kind of complying with the DSA, doesn't entail violating the GDPR. So I have no idea how that is going to play out, but I do think that there is going to be this very specific, there will be this specificity of the planned activities. You need to explain exactly what you're going to do with the data, what your expected results will be. So that's why, while it is true that indeed having, maybe your university as a university that is recognized through a charter in Germany, and it has this public status, that is a very important institutional dimension. I still believe it's going to be vetted researchers, is going to be a project group that will have to show, we have this institutional affiliation, and this is the project that we want to pursue, and this is how we're going to do it. So there will still be these applications. That's why I wanted to emphasize, the bureaucracy, because here it comes.
Thank you so much.
But maybe I had a question for Taylor. So yeah, this is because Taylor, you were looking recently at this the entire discussion about children and risks on social media. So what is your opinion? Looking at the very diverse field of study and also very diverse results that can be found in this field. How can we frame that as a systemic risk? Where would we even start?
Yeah, I think it's a massive question because, as you say, there is such mixed results. And so I guess the conclusions of a lot of the research is we need more research because we can't tell yet what kind, can we be talking about direct impact on well-being and mental health of young people when there are so many other factors to take into account. And I think this idea of data access and how that might help in this situation is kind of exciting. And I guess the question that's raised for me, I know in other parts of the DSA, platforms are having to undertake these kind of assessments of systemic risk, and then that becomes audited. Do you think that there is scope then for the platforms to be determining what they think are systemic risks, and how then these coordinators may be put in a position, what kind of politics may be involved if a research community is saying, hey, we think this might be a risk, but we don't know yet because we need access to your data. And then, yeah, does this become a catch-22 if we say, hey, look, there's not enough evidence, but we think there could be something here based on this kind of small, these pockets of small research? I don't know, how this kind of then all plays out, or whether that becomes a tricky position for researchers to kind of be trapped in this lack of access.
I think that is so again, putting back the administrative hat, and although that is the most boring part of a discussion, I think that's also one of the most relevant ones, because I think that will very much depend. So imagine that you have maybe, I don't know, like a list of you're the Irish National Service Coordinator, and then you have a list of 300 researchers, and then some of them want to look at maybe risks that we don't know if they're there. Some of them want to look at risks that are so relevant for very specific areas. I think that we need to acknowledge that there will be a competition for resources, and then how that is going to play out, I have no idea. We can all kind of do wishful thinking, but I think this risk discussion is one of the most the prickliest discussions in so many fields of regulation. You look at generative AI, look at also social media in general, because we haven't done enough cross-fertilization with other fields, for instance, like public policy, to use methodologies that actually model risk and to say, okay, let's look at risk in a relative context. We have this risk, but maybe we have also 20 other risks. So I think that this is the scale that I was talking about earlier, where we as researchers, I really think we will need to step up our game and think at a much higher meta level than we have been doing so far, and then try to also understand, okay, this is the big picture. What are we missing here? Who are we missing from the table? And then bring them, develop collaborations, and then try to see systemic risks. Have a look at all of the papers from Nature, and also the project of Meta on elections, and you can see how huge that was. And I think that this is, for me, the best example of that. But yeah. Looking at the fact that we exceeded our time, Tom, back to you.
Yes, I mean, we do have, maybe you want to have a quick response to the question in the chat.
Eleanor, do you want to perhaps say it out loud?
Sorry, yeah, I'm a media studies person, and I'm based in Ireland, so was interested in your slide on with the number of companies that are going to fall under our jurisdiction. But from a media studies point of view, one of the challenges, especially methodologically, is what to do, I guess, with content that people are posting themselves. And I guess traditionally, as a media studies person, you would have had discrete media experiences where you could look at a TV series, or you could look at a film and or a group of films and study them. The challenge with social media is that you don't have these discrete media experiences. Some of the ways around that, I guess, that people have used is like using scraping tools to take information off platforms, or simply searching and downloading content or comments or whatever from people around a particular subject. And I was just wondering where that sits in relation to this legislation, you know, within GDPR, but also the new legislation. Is that captured in there, or what are the kind of legal implications of doing? I guess it was kind of a Wild West approach to studying those for a certain amount of time because nobody really knew what it was. But I'm wondering, is it captured anywhere there, please?
That is a fascinating question. And also, congratulations on having like a first row to become a vetted researcher once the Irish National Service.
that may be a blessing or a curse, depending. Yeah.
That is fantastic. But I think that, yeah, Claudio was also mentioning this, I think, in the first webinar that we had. And I see him already jumping into the chat, because I'm just going to mention one thing. And then, Claudio, please just build on what you were saying in the chat as well. So I think that here we need to think about looking at systemic risks from multiple perspectives. We have auditing, that's going to be KPMG going into Facebook and then taking all of their internal documents, all of their processes, and trying to say, have you kind of done a good job? Did you do your due diligence in understanding how you're impacting society? Which I think is it's in a way, it's a very reasonable question, but it's also a very nasty question. As we have some colleagues from Utrecht University who have been developing a fundamental rights impact assessment for AI and the use of AI in public administration. And there's a question there in this very nicely sounding fundamental rights impact assessment that literally asks public administration, what fundamental rights are you infringing? Well, you know, how many decades do we have to have, how many tons of PhDs can we do on this topic? Because it's not something that you can just immediately answer. You know, who on earth thought when Mark Zuckerberg was developing the Facebook just to look at hot women or like rate what he thought were hot women, who the hell had an idea that that's going to completely derail the US elections, you know, I don't know how many decades later. So I think that this is the problem of risk regulation. So we have auditing, we have data access. So data access doesn't cover scraping as such, like the Wild West of scraping. But in my perspective, I think that there can be more room for scraping as an external checkup of, you know, what kind of data are platforms giving you, and what kind of knowledge do you gain from auditing? Because the problem is that right now, we do not really have a very specific protection for scraping, but at the same time, it depends also on how you interpret and what you do with data and how you interpret that as well. So I don't think that in principle you would have, but again, I'm just going to add this with a pinch of salt. In principle, as a researcher, you should be able to scrape a website, but then if you want to publish in a computational journal and they ask you to publish the data, then that is going to be a very big problem. So, but yes, but I think Claudio is first. In the meantime, I'm going to look at Article 12, you said, Daria. I will just check that.
No, it was something you were talking about before, that public information should be available to ordinary users. And I think I was at the Amsterdam Law School and they were talking about this cover scraping.
Right. The thing is that in principle, Article 40 is about data access. So how I would interpret it is there should be an API through which a platform allows for access to public data to these other organizations than research organizations. So, but I think that there's a debate around that. So yeah, but Claudio.
Yeah, just, I mean, what you said, Catalina, was perfect and comprehensive. I just want to add the reason why I believe there is an etymological problem. Scraping in the last decade has been quite ostracized in the US law or regulation because it was normally associated to unfair market practice. So like scrape a database of customer and then reach out to them to build your database. And this kind of scraping tendentially fell into some kind of computer fraud kind of act. This scraping that in the modern time has been referred as a problem is the one made by OpenAI, but is not technically different from what is made by Google search engine, and is what in technical term should be referred as crawling, as something that in an automatic way take everything and do their own use. Instead, if you look at the campaign made by the markup, scraping is not a crime, or at the cease and desist that the Meta sent to Algorithm Watch that was analyzing the Instagram algorithm, or also when Facebook, to the organization Tracking Exposed, made a takedown of a browser extension meant to analyze the Facebook algorithm. Now, those behavior, they are technically scraping, as scraping is something that transforms human readable information into a machine readable format. That is what it matters. And when you're doing algorithm analysis, you need to study what the platform is giving to you. So you need to transform a newsfeed into a CSV. And that process is what we call scraping. But because of those loaded background, sometimes also when you interact with the academy and you mention that your methodology includes scraping, that is a red flag for them. In my opinion, it's a matter of better clarify those terms and also explain what are the provisions into the DSA that can legitimize independent audit to actually exist.
I thank you so much for making this distinction. I think it's quite relevant. The thing is that I think that it depends a little bit on from which perspective you look at it, because also if you look at internet governance, there's this very nice paper by Ian Brown on the prehistory of the internet. And if you think about also, for instance, like the architecture of the World Wide Web, crawling for the purpose of indexing web pages is different than scraping for the purposes of data collection. So at least that is one distinction that I would make from the perspective of this early internet technology, so to say. Now, the fact that if you have the very big dark patterns study that was done in 2018, and you have you have a crawler and a scraper just working simultaneously, and what you're doing is you're automating the visiting of websites and then gathering data from them, then basically that is something that kind of, I think, removes some of the boundaries between scraping and crawling. But I completely understand the distinction. I think that in a way we've also done this to ourselves, this kind of fear of scraping. And I will give you the example of natural language processing conferences, which I'm somewhat familiar with, where even the ethical, so this is what Dan is mentioning, web scraping being considered unethical from the perspective even of peer review and even from the perspective of ethical codes of these conferences. And it's very funny because it's conferences who really had a problem with platform power and with platform funding, but at the same time didn't have a problem with platform power expressed through terms of service, because this is where the fear came from. Oh, YouTube is saying you cannot, well, YouTube has a good API, so it shouldn't be an example. But for instance, LinkedIn has, that was also an example in one of the cases that I think you were referring to. It was a case on scraping in the United States. LinkedIn has a term, it says a clause, it says you may not scrape the contents of the website. Therefore, if you're a researcher and you go against the TOS, that's not ethical for us. So that was, I think, again, like that's a problem that researchers have created for themselves. In that LinkedIn case, it was like LinkedIn versus HiQ or something like that. It was actually a good case for HiQ because it was considered that scraping was legal. But I know that the case law in the US, at least, was very all over the place about this computer fraud. And it is true, but also in that situation, it was a situation where you had a company that was scraping another company and wanted to create a commercial product, and not a researcher looking at, okay, how can we ascertain for the purpose of publishing a peer-reviewed article and not developing a product, how can we ascertain issues? So, but yeah, that's the last thing.
Great. Wow. Thank you so much. That was the end of our ride. Thank you. That was a very interesting, intriguing, lots of food for thought. we're gonna end our session, our first series, which was a very interesting and sweet experiment with an intimate group of people that came every week. So that was great and really motivating for us to have another. We are already thinking and envisioning our next series. So we're still in kind of like thinking about that, but we'll definitely do and announce relatively soon something new. We are thinking of monetization, but we'll let you know more as we will get our mind around that. And yeah, so I just want to thank you for allowing us so much of your brain and knowledge, Jacob and Catalina. And thank you, Taylor, for being my co-host. And I'm wishing you all a great night, and we'll be in touch very soon. And we will release the recordings in a kind of like organized way through a YouTube link. So we will do that. And thank you so much, everyone.
Thanks so much. And thank you to you, Tom.
Thank you.
Have a lovely evening. Bye.
Bye.